whatever comments I make are purely in my personal capacity and has nothing to do with the government of Kerala. I am assuming. That's something. Second, see, we have this judgment of the Supreme Court before us, rather a long judgment running over 18 pages, more than 200 pages. And it is rather time consuming to read the whole judgment and analyze the contents of that. Anyway, I had to do it. Even before this program was fixed, I had to do it because government is very much concerned about the implementation of the judgment and they had to give my inputs in that process. Now, most of you are familiar with what Cardoso has written about the judicial process in a small but very thought-provoking book, The Nature of the Judicial Process. In that book, Cardoso says that every judge has choices. Whenever deciding a case, a judge has a lot of choices before him, and very often the first choice of a judge is to decide according to logic. But logic doesn't compulsively lead you to a particular conclusion. Logic will present many choices again. Then how do you go? How do you proceed to decide a case? Cardoso says you may follow either the method of history, method of philosophy, method of sociology. So many methods are suggested by Cardoso, who himself was a great judge as well as a jurist. Now, in this judgment, we find that both the High Court of Kerala as well as Supreme Court of India have relied on history. But the way in which history is made use of in the judgments differ. I will come to that. Now, first of all, if you analyze these two judgments are before us. The High Court of Kerala judgment and the other is the Supreme Court judgment written by Justice Lalit. So, one way of looking at these judgments is from the logical angle, whether logically consistent and coherent these judgments are. More important, I feel, is to analyze these judgments from a sociological point. What is the social impact that this judgment is going to produce? Is it the kind of social impact that we want a judgment to produce in our society? Because every judgment is a very important piece of legislation, I should say, and its impact on society is very great. So, what is the social impact of the judgment that is produced? Unfortunately, we find that in India, very often people react to judgments, but incisive analysis of the judgment is not seriously taken. I appreciate this venture, the Center for Legal Change, in organizing this program, because especially now we are all our attention is focused on COVID-19. In fact, everything gets else some sideline. So this discussion is at a very opportune moment, and they congratulate the organizers for that. Now, what did the Kerala High Court do about the dispute? There was a dispute, of course, about the management of the Sri Padmanabha Swami temple, the legendary temples of Kerala, internationally known. And now, why the Padmanabha Swami temple is considered very important because it is considered to be the richest temple in the world, not in India, but in the world. So that is something. Secondly, it's the ancient origin historically. People's faith in the temple is very, very great. So, how has that temple to be managed? How is it to be administered? So, it's a question. You know that the royal family had a dominating position in the administration of the temple, rather than the royal family. And they naturally wanted to continue that position even after their privileges have disappeared. Privileges have been taken away very long. Even the status of ruler has is extinguished by constitutional amendment. As far as temple, Padmanabha Swami temple is concerned, the royal family has a sentimental attachment to the temple, you can understand. But more importantly is their claim to remain as a trustee, a managing trustee of the temple and all the affairs of the temple. How far this is sustainable? There are people who are agitating even in the lower courts of Kerala about so many things connected to the temple and arguing, contending that the royal family's claim to administration of the temple is legally not sustainable. That argument was. Now, when this is heard by the High Court of Kerala, I would say that High Court of Kerala's judgment is very logical. It reveals a very rare kind of social awareness and very practical. The logic is very simple. There is no strained reasoning anywhere in the Kerala High Court. The reasoning goes like this. The Travancore royal family was in control of the Padmanabha temple, as they represented the public interest. The state, the government, can be equated with the royal family because those were the days of the monarchical privileges, rights. They were there. So, as representatives of the people, as representatives of the state, as representatives of the government, Travancore royal family was exercising control over the Sri Padmanabha temple. That continued. But once law has changed, once the authority of the royal family was legally abolished, all their privileges have been abolished, and even the definition of ruler which appears in Article 66-22 after the 26th Amendment to the Constitution in 1971, that also doesn't confer any title of ruler on any descendant of the last ruler of time. This is very clearly established. And the High Court proceeded on that assumption. There is no ruler now, no successor now. Therefore, whatever rights were vested in the royal family or the ruler of Travancore in trust, as far as the Sri Padmanabha Swami temple is concerned, they no more exist. Then what is to be done? Today, the state is considered to be the custodian of public interest. The temple is a public temple. That's undisputed. Even the royal family of Travancore, who were writing this case in the High Court of Kerala as well as Supreme Court of India, they considered that the temple is a public temple. But we are administering the temple in public to safeguard public interest. We are the repository of public interest. And that claim be upheld in a democratic state. And this has to be viewed in the background of the scenario of all temples in Kerala. See, there are a large number of temples, like Guruvayur temple, which has a long history, ancient temple of Guruvayur. The Punadura temple, which was considered as the family temple of the Cochin royal family. Guruvayur temple was considered as a family temple of the Samorin of Calicut. What is the position now? Other temples, maybe more than 1,000 temples are under the Kerala Travancore Devaswam. They are administered by a statutory body which has been established after the enactment of a law, Travancore Cochin Hindu Religious Institutions Act 1950. This Act of 1950, incidentally, devotes a whole chapter. In Part 1, Chapter 3, The provisions on Padmanabha Swami temple are enumerated. It provides for the administration of the temple. It provides for annual grant to the Padmanabha Swami temple. So all these provisions are there. So my contention is that after the 1950 Act came into force, neither the covenant nor the historical position which was held by the Travancore royal family or the ruler of Travancore remains relevant. It's all governed by law. And whatever disputes arise and how they have to be settled is a matter of the lawmakers. And this is a situation where the lawmakers are made to do that and judiciary have to step in. Another interesting thing about these judgments, especially the Kerala High Court judgment, that the state did not take a categorical stand. The state was all along maintaining the position that the ruler of Travancore is the first. Their right to administer the temple is undisputed. The state of Kerala has never stated a claim that we are the custodians of the public interest. The government of Kerala is the custodian of the public interest. We will assert that right. We will administer the temple in public interest. We will assume the role of the trustee. As in the case of other temples like Guruvayur temple and the temple in Kochi, this could have been done by the state. At one point, the judgment of the Kerala High Court says that we are disappointed. We are disappointed by this attitude of the state court because they have failed. They have failed in their duty. We do not think that the approach of the state government is fair, reasonable, or legal. This is the observation of the Kerala High Court. So even in the absence of a categorical stand by the government of Kerala, High Court of Kerala has argued the case on a logical basis. The history, the argument that history supports history and custom, perhaps, support the royal family has been negatived by the Kerala High Court. History doesn't start at a particular moment, or a particular event, Great things are said about how Martanda Varma, the King Martanda Varma, unified the state of Travancore and then placed the entire kingdom on the feet of Sri Padmanabha. This is Tripadi Dana. After which the king of Travancore ruled the state as Padmanabha Dasa, a slave or a servant of Lord Padmanabha. That is perhaps the single most important event which confers a title on the ruler of Travancore to assume control over the administration of the Padmanabha. But what was the position before this? Before Martanda Varma. Before Martanda Varma consolidated his position as the ruler of Travancore, the Padmanabha Swami temple was under the control of what is known as Yattara Yoga, 8.5, a committee of 8.5. Very interesting because this half in Yattara Yogam represented the king. He had only half, not even one vote. In this committee of 9 persons, 9 persons were there, but the king's presence was only half. He was able to name right to half. That was the position of the ruler of Travancore before Martanda Varma's consolidation of power, and Martanda Varma continued to rule for a long time. By which time, the control over Padmanabha Swami temple, control exercised by the royal family over Padmanabha will rather absent. It will be accepted. But we cannot also the rise to earlier history. Earlier history which establishes that the role of the royal family in the administration of the temple was best. Their right at the most was a right to participate in rituals, as well, like arat possession, or certain rituals which are connected with when a child in the royal family becomes one on his first birthday, there are some rituals connected in the family temple. So many things are there. And nobody is questioning the rights of the royal family to take part in rituals or in worship. These are all questions of belief. These are all questions of faith. Nobody answers that one. When it comes to administration of the temple, it is very much a matter of secular considerations, because public money is poured into the coffers. I said the Kerala High Court decision is sociologically very significant and acceptable because at one point in the judgment, the High Court very clearly says that faith cannot be made a matter of business. Nobody can be allowed to exploit people in the name of religion, in the name of belief. So there must be some check. What will happen if the member of the royal family, the successor in the rule, gets control over the Padmanabha Swami temple? He may be corrupt, he may be immoral. Generations succeeding earlier generations, there is a great deterioration in values. So, in order to ensure that faith is not made a commercial activity, the High Court of Kerala categorizes that the government has to take over. Even though the government of Kerala did not make such a claim, they did not press such a demand, High Court found that the best interest of the community was lost. Better that, as in the case of other temples in Kerala, administration is vested in the state. State will be the trustee. And something like the Guruvayur model, enacting a separate law for the temple, constituting a committee for the administrative temple, in which perhaps the royal family of Travancore may be given some representation, as the Samorin of Calicut is given representation in the Guruvayur the temple administration committee of Guruvayur temple. So this has been suggested by the Kerala High Court and direction issue, agreed by the decision of the Kerala High Court. Sri Martanda Verma, who is to succeed Balarama Verma, and Balarama Verma was indisputably the last ruler of Kerala. He was Raja Pramukha of Travancore, Kochi. And on his demise, Sri Martanda Verma, his younger brother, has succeeded to the guardian. He has claimed rights of the ruler of Travancore. So he was a petitioner originally, but in the course of the litigation, unfortunately, Martanda Verma also, his demise took place, and his successor, Aditya Verma, successor took over. So finally, after protracted litigation, High Court judgment was delivered in 2011. 9 years after that, the Supreme Court judgment has come. What makes the judgment of the Supreme Court radically different from the judgment of the High Court? The appeal stands allowed, and very strange logic, which very difficult to understand. Because the concept of the buyer may not be known to many. And even I don't think that the royal family was claiming any Shabai rights as Shabai of the temple. But ignoring all the constitutional as well as statutory developments and making reference to history in a very selective manner. Supreme Court of India said the royal family is not staking any claim to the ownership of the temple, but they are staking a claim only to the administration of the temple, which we are allowed. And the court suggested that there could be an administrative committee to manage the day-to-day affairs of the temple, an advisory committee which will look after the policy issues and guide the administrative committee. There will be an executive officer who will be concerned with the implementation of the decisions of the administrative committee of the temple. And Supreme Court is confident, appears to be confident, that public interest will be protected by these measures. At the beginning of my talk, I mentioned that the Padmanabha temple is considered to be the richest temple in the world. Nobody exactly knows what's the value of the treasures that are kept in the temple. Some of the showrooms are yet to be opened. Open because there was some belief that opening those Telavaras will be detrimental to the society at large. So people are not prepared to open back. There are also committees appointed by the Supreme Court which made audit. Audit was not being properly done, regularly done in the case of the huge income that came into the coffers of the Padmanabha temple. There have been a number of allegations that money has been plundered, wealth has been looted. And even the Vinodare committee report is that there are no satisfactory explanations on so many transactions. Because there is no proper accounting, no proper audit. People very often may not be knowing whom authority is vested and whom to obey. And commands come from different sources. So there was a kind of unsatisfactory state of affairs in relation to the administration of the group of Padmanabha Swami. Ad hoc committees were put in place. And finally, the district judge of Trivandrum was given charge. Now, that is going to be made a permanent mechanism. Here again, my doubt is, do we have to spare the service of the judiciary? The district judge of Trivandrum has so many judicial functions. The delays in the judiciary, delay in the disposal of cases has become proverbial. Justice delayed is justice denied. We repeat it so often. Now, in such a situation, we should spare the services of the district judge, or even though it may be part-time. District judge of Trivandrum, who shall be a Hindu, must be the chairman of the administrative committee. If this is cited as a precedent and in a number of churches in Kerala, disputes are going on. Fortunately, the Padmanabha Swami temple dispute did not generate any law and order problem in the state, but church disputes are generating law and order problems in several parts of the state. Hundreds, even thousands of followers of the Christian faith, they join together, they reach a church and assert their right to worship in the church, but another section is there. They will prevent them from entering the church. So this is going on in spite of Supreme Court judgment. So can anybody say that, okay, let us leave the administration of the church to the district judge of the area? The district judge has territorial jurisdiction. See, this is a matter which concerns only the believers who have faith in the Hindu religion. In a secular state, is it justifiable that we burden the judiciary with the administration of a temple which is, not a particular religion, concerns only a particular religion? So even that way, the decision of the Supreme Court appears to be very unsatisfactory. And the way in which the Supreme Court has achieved this result is by totally ignoring an amendment to the Constitution, the 26th Amendment, which was enacted in 1971. Supreme Court says that the definition of ruler in that amendment is only relevant for purposes of the Constitution, not for anything else. Because the time is short, I am coming to one more point and give it to you to discuss. Now, I mentioned about the 1950 Travancore Cochin Act. It has devoted an entire chapter, chapter 3 in part 1, to the management of the Padmanabha temple. Those provisions are there. The Supreme Court has not invalidated any provision in the Travancore Cochin Act. Those provisions survive. And some of the directions of the Supreme Court of India are directly contrary to the provisions in the 1950 Act. So, what should we do? Whether we should obey the mandate to the 1950 Act, provisions of the 1950 Act, or what should we do? Or the directions of the Supreme Court. If you don't implement the directions of the Supreme Court, immediately contempt of court. But a statute is there. There is a principle which we call deference to the legislature. The legislature is presumed to represent the will of the people in a democracy. And when a piece of legislation enacted by the legislature is there, its provisions continue to be valid and operative. Is it right on the part of the Supreme Court to issue directions which are contrary to the provisions of the Act? It's a genuine doubt which arises. And when the Parliament of India enacted the 26th Amendment, this is very important sentence in the Statement of Objects and Reasons. Statement of Objects and Reasons says the concept of rulership with privy purses and special privileges unrelated to any current functions and social purposes is incompatible with an egalitarian social order, which we want to promote through the Constitution of India. Government have therefore decided to terminate the privy purses and privileges to the rulers of former Indian states, including, of course, the state of Kerala. Now, let me ask you, even when we say that the administration of Sri Padmanabha temple was vested in trust on the ruler of Travancore, is it really in his capacity as a person, as an individual? No. This vesting is in the ruler of Travancore, the state of Travancore, the government of Travancore. Because the ruler in those days was the embodiment of the state. That is how administration fell on the ruler of Travancore in first. The moment they lost their power to rule, the moment this kind of equating the king, the ruler with the state ceased to be there, the democratic government assumed power. The democratic government became the repository of public interest in a modern state under the Constitution. These arguments which are based on rulership rights, special privileges, they don't survive. They don't deserve any respect, any recognition by any competent court. So this is the reason why I find the Supreme Court judgment unsatisfactory. Logic. Even if there's a logic, it is a straight logic, very straight. And from a sociological perspective, it is very unsatisfactory because it doesn't do justice to the concept of a secular state. It doesn't do justice to the will of the people as expressed through legislation, not in the Padmanabha Act, but also by Parliament. Parliament which enacted the 26th Amendment, they are nullified the 26th Amendment, like that it is of no consequence, no relevance. A decision like this needs stronger justifications, stronger support of logic, better logical consistency. But unfortunately, these are all absent in the Supreme Court judgment, and I would like to say that the High Court's decision, the Kerala High Court decision was more logical, more socially desirable and acceptable, and more in tune with the aspirations of democratic aspirations of
Thank you.